come back. Okay, so let's see. I'll set it for January the 30th of next year at 9 a.m. If that finishes you up, then you don't have to come to that hearing. January 30th. Just check back with either Mr. Cooper or probation officer.
I'll walk out and talk to him.
Okay. Your name, sir?
Alex Wellman.
Alex Wellman is 2125. Falsification. You've paid your fines. You still have some community service to do.
Should have 24 hours left.
That's correct. Okay. I'll set you for January 30th also. If you get it finished by then, you don't have to come back.
Yes, sir.
9 a.m. January 30th. Okay, the other people who did not appear because of the weather, I'm going to give them 2 weeks to appear rather than usually it's 7 days before a warrant. Because it's holidays and really bad weather, I'm going to make it 2 weeks. So if they haven't appeared by January the 6th, then a warrant will go out.
Dylan Wilson, Chase Webb, Kevin Allison, Casey Barker, Jennifer Farley, Jeremy Meadows.
Okay, sounds like we got Melissa Weaver and Kevin Allison, I see. Let's do the ones here. Your name, sir?
Dylan Wilson.
Dylan Wilson. Case number is 21-2786. It's on an OBI. You completed your community service. You're making payments on your fines, which you did do. A payment this month. Have you done the driver intervention program yet?
No, sir, I have not.
Okay, well, you need to do that. You're aware of what your requirements are on that?
Yes, sir.
Okay, you gotta get signed up for that, get it completed. I'll set yours for January 30th. Next hearing is January 30th, 9 a.m.
Okay. Thank you, sir.
You're welcome. Your name, ma'am?
Jennifer Farley. I turned in 2 days community service today.
That is correct, Your Honor. I have a note that she was supposed to be here on 11/22, that's on a Tuesday. I believe she was here, I haven't had time to look that up.
Okay.
But I know she was here.
Yeah, but actually it shows that she worked at Chesapeake Schools that day.
Yes.
All right, you've still got some community service to do. You did get a payment on your fines today.
Yes.
So we'll keep working on that. January 30th,
Okay.
9 a.m. is your next hearing.
Thank you.
You're welcome. All right, Kevin Allison, I have his file, and I see he's appearing by teleconference.
Recording has started.
All right, this is for Kevin Allison, case number 22-17-59. It's on an OBI. Okay, are you in a treatment program now, Mr. Allison?
Yes, I was at the Huntington Treatment Center, and I had to lower my dose of messaged them, and they lowered me down, all the way down to 30, and then this past week has been the 5 days that I've been off of it. I have to wait, to get on Suboxone, and I was going to switch over to Proact. At this
Okay.
point, next week.
Where are you, so you're not inpatient now, you're an outpatient program?
Well, I'm an outpatient with Huntington Treatment Center currently, but I plan to switch over to Proact next week.
Okay, so you're,
One call.
because at one point you told me you were thinking about moving to Wyoming, but that's not happening now?
No, it is. I didn't want to get on the Suboxone before I left.
Okay. All right, well, we can work with Proact, so you're planning on getting on Suboxone with Proact, correct?
Yes, before I leave, yes.
All right, well, and when are you planning on going to Wyoming?
Probably be after the first of the year. The plane fare tickets right now are really expensive for the holidays. I've been in contact with my father, and I'll probably leave it at around the first of the year.
Okay, well, I'd like for you to come back and show me your own Suboxone, so let's make it for
Okay.
January 3rd. That's the first court day of the new year. January 3rd, that's a Tuesday.
Okay.
January 3rd, 9 a.m., and I'm making a note that you'll need to go see, have you already been to Proact yet, or not?
No, I still need to go there this next week.
Okay,
If
yeah.
I can,
You need to get in there, I want to see a report from them that you've been there.
Okay.
All right, I'll see you on January 3rd at 9 o'clock.
Okay, thank you.
You're welcome.
You're on.
Okay, the remainder of the people, I don't think, see, I've got Mark Seymour and Melissa Weaver. I don't have their files yet. So the other folks that were called and didn't appear get 2 weeks before a warrant will issue. This is all we're using.
Chester Ramey, Terry Fannin Jr., Caleb Ham, Alicia Clay, Eric Fuller, and Jonathan Harris.
All right, your name, sir?
Jonathan Harris.
Jonathan Harris is 21472. Is a domestic and 19764 possession, 19846 protection order. Okay, you have done some community service since your last court date, so that's good. Do you have any payment on your fines today?
It won't be till Tuesday morning.
All right, I'll set your next hearing. January 27th. January 27th of next year, 9 a.m. is your next hearing.
Okay, thank you.
And your name, sir?
Eric Fuller.
Greg Fuller is 142273. You've got community service and fines. Cost to pay. Do you have any payments today?
Not today. I paid $200 yesterday.
Okay, that is correct.
Do you have a question?
Yes, sir.
I've been working community service in Athalia. I turned my hours into Cody. He's the cop. I'm not sure of his last name. And he said he turned it in, but I'm not sure if he made it yet, so.
I have not received it.
Okay.
Okay. If he doesn't turn in, get a copy yourself, turn it in yourself. We can
Okay.
verify it. All right, January 30th will be your next hearing. 9 a.m., January 30th. That's all.
Your Honor, Chester Rainey is at Bethesda.
Okay.
I sent in a letter, he's compliant with all treatment recommendations, negative drug screens, he's doing really well in the program.
Okay, very good. I'll set his next review hearing for January 30th.
Thank you, Your Honor.
All right, Terry Fannin and Caleb Ham.
Your Honor, here's the letter. Okay.
Okay. He called in and said he couldn't make it today. I give him 2 weeks to get here. He said he would be in Tuesday. That finishes it? Okay, that finishes the reviews. We have some arraignments to do,
No, we don't.
just at the jail.
Just at the jail, that's all.
Okay, let's get the jail online.
Okay.
See if we can do this.
I don't even have those folders yet, Your Honor. So,
Okay.
what is that, your pre-trials or prelims or sentences?
Well, they're not set till 10, so let's just take a break. Court's going to be in recess. We'll come back when we get ready to do the arraignments from the jail. Court's in recess.
Am I being seen today?
Yes, ma'am.
Okay, sorry.
I'm not saying, I didn't say anything.
He's gonna be on plane, he has a emergency setting. The screen, yeah. I know that, yes. I got the paper, no, close, it's close, Chesapeake is close. She said when we get the other conference. Okay. Okay. Thank you.
Filipino back here?
You're out of jail.
Is he back here?
Yeah, you want me to tell him?
Yeah, can I?
Yeah, let me get this really quick.
You sound like he's happier than my old lady.
Huh?
You sound like he's happier than my old lady.
Yeah.
not locked up.
Yeah.
Yeah, he's in the tank in there when we come through. Well, good. At least he did pay a little bit attention.
What were those grants we were talking about again? Felony grants?
Pell grants.
Pell grants?
Don't have to pay it back. No, I had to put up my farm to get out. 50 grand. That died. Or it get rain or wherever, rain winds or wherever, they put a ramp on it. I'm just here for some receipts and bullshit. She was fine, but I hired a lawyer and I'm not going to review. I have I'm very happy that I hired a lawyer.
I called for Richard Dash.
Yeah.
When it won't get back to me. I do call Julie, you better take my case, because he's my friend's lawyer.
Yeah, I'm driving my golf truck. Well, I got a trailer.
Oh, please come to order. Next case is State of Ohio versus Joseph B. Conley, case number CRA 22812 at the Lawrence County Jail.
Okay, we're back on the record doing arraignments, prisoners at the Lawrence County Jail. And I do not, we got the jail, but I don't have a video from that. There we go. All right, sir, are you Joseph Conley?
Yes, sir, Your Honor, sir.
Can you hear me okay, Mr. Conley?
Yes, sir, Your Honor.
All right, Mr. Conley, I'm going to go over your rights with you. I'm Judge Capper at the Lawrence County Municipal Court. This is your,
Yes, sir, Your Honor.
this is your arraignment hearing, and this is all being recorded. The video and audio is being recorded. So what you say is on the record. If you admit something, it can be used against you. You have a right to remain silent. You don't have to make any statements. If you have a right to have an attorney, and you have a right to have one appointed if you can't afford one. You have a right to have bonds set for you and to make the state prove any charge beyond a reasonable doubt. Do you understand those rights I just explained?
Yes, sir, Your Honor, sir.
Okay, your charge is a domestic violence charge. It's case number 22812. It alleges that at Perry Township on December 21st, you knowingly caused or tried to cause physical harm to Lori Hamilton, and that Miss Hamilton is either a member of your family or a member of your household. So that's what makes it a domestic violence charge. It's a felony of the 4th degree. Maximum penalty is 18 months in jail and a $5,000 fine. And the reason that it is a felony is because the state's alleging that you have a prior conviction for domestic violence. That's what makes it a felony. Do you understand the charge against you, sir?
I understand what you told me.
Okay, you don't have to agree with it, but you need to understand what you're facing as a charge.
Yes, sir.
Do you have the money to hire a lawyer?
No, sir. Am I allowed to speak, Your Honor?
Well, you can, but I want to remind you again what I said at the beginning. Everything is on the record, so if you say something that is damaging to your case, the prosecutor can use that against you. So the smartest thing for you to do is wait, because I'm going to give you a lawyer if you qualify, and talk to your lawyer, because with the attorney you have what's called attorney-client privilege. Whatever you say to your lawyer can't be used against you, but whatever you say in open court is on the record and it can be used against you. So it's probably better just to wait, tell it to your lawyer, and then if it's something they think that I really need to know, they'll come and put it on the record and let me know about it.
All right, thank you.
All right, so I'm going to appoint Mr. Steyer to represent you. We'll get him, he's here today. I'll get him in the courtroom. He'll probably call down and talk to you about your case.
Okay.
Okay, here he is. Mr. Steyer's in the courtroom, so if you look at a certain screen there, you can see him in the courtroom. He's waving at you now. This is Joseph Conley. He has a felony for domestic violence. It's alleged there's a prior conviction, which makes it a felony level. It appears that he's qualified for court-appointed counsel. And you came into the jail yesterday, is that correct, sir?
No, sir.
Wednesday, okay, that's correct, on the 21st.
I'm here the 27th and the 30th.
Well, let's get the prosecutor in and see what his position is on bond and hearing date. He has some things, Mr. Connolly had some things that he wanted to say today, Mr. Steyer, and I told him it'd be smarter for him to talk with you about, and you'll put it on the record if you think it's important to do so. All right,
Thank you.
Mr. Heald is here. This is Joseph Connolly. It's a felony for domestic. What's the state's position on bond? And we could do the preliminary either on this coming Tuesday or next Friday. It would be within the time frame because he went into jail on Wednesday the 21st.
Well, I guess any consideration of bond also there needs to be a consideration of
Protection orders.
staying away from Lori Hamilton. So I'd like to know whether he has someplace else to go if he got out.
Would you have a place to go if you got out of jail and couldn't go to where Miss Hamilton is located?
Yes, sir.
Where would that be?
My mother's.
Where she live? Chesapeake?
Yes, sir.
What's her
And
name?
or I can stay at my boss's.
What's your mother's name?
Teresa Lynn. Or I can stay at my boss's.
Where's that located?
Highland Memorial Gardens in South Carolina.
Sounds like he's got a couple options then, Your Honor.
Mr. Heald?
We would ask for a $2,500 cash assurance bond and an order to stay away.
Your Honor, he has local places he can go. We would ask for an OR bond and would agree to an order to stay away.
Okay, I'm going to let you, now, are you promising to stay away from Miss Hamilton?
Yes, sir. Your Honor, yes, sir.
And by that, I mean not only stay away, don't go around her, don't contact her, don't post anything about her on social media, don't text her. I don't want any contact or any, I want this to die down. I want there to be some sort of incident that causes additional charges to be filed while you're out on bond. You understand that, sir? So that means totally stay
Yes.
away, don't instigate anything.
Yes, sir, Your Honor.
Okay, so I'm gonna let you out on your promise to do that and a signature bond. So I'm gonna let you sign a signature bond, and don't make me look bad, because the prosecutor wanted me to have you post a cash bond. You understand that? And I'm letting you out on your signature. So I'm not gonna be happy if there's an incident while you're out on bond.
My probation officer, the chief probation officer already has like a holder on me, so like with that.
Well-
How does that work?
If you have a holder, you're not gonna get out when you bond on this. But if you don't have a bond on this, then the probation can't let you out either. So it's kind of a two-step process. This will take care of this holder, and then probation department may say, well, if you've got an OR bond, we'll let you out, or they may say you gotta sit there.
All right, yes, sir.
Where are
I
you?
just wanted to let you know.
Where are you on probation?
Lawrence County.
So, he, probably common pleas.
Yes, sir. Tyler,
Okay, I know who you're talking about.
yes, sir.
All right, so I'm gonna set your next hearing then for probably the 30th is better.
Probably, I would assume.
December 30th. So if you're out of jail, you have to come to the court in Chesapeake on a week from Friday. That's today. I'm kind of confused on my date. December 30th is a week from today. So you have to be here. You know where the court is in Chesapeake?
Yes, sir. Across the street from the, court.
Yes, sir. You got to be here next Friday. Of course, if probation doesn't lift their holder, you're going to be sitting in jail. So I'll see you on TV monitor just like we are today. If you get out, you have to stay away from Miss Hamilton completely and totally, and no social media contact either, or mention of her. Okay. Mr. Steyer may get in touch with you. Do you have a cell number in case you do get out where he can reach you?
Yes, sir.
What is that number, please?
740-442-0234.
Okay. Hey, that's a cell phone?
Yes, sir.
I'll send you a text message.
All right, thank you.
Thank you.
And Mr. Connolly, your hearing in this court is next Friday at 10 a.m.
10 a.m. on the 30th.
Yes, sir. Okay, that's all, sir.
Do I sign anything?
They'll send something down. They're going to send a protection order down for you to sign here in a few minutes.
All right.
State of Ohio versus Daniel J. Markins, case number CRA 22-811 and CRA 22-813.
Okay, Mr. Connolly, you let the next person come in. Sir, are you Daniel J. Markins?
Yes.
All right, Mr. Markins, I'm Judge Capper at the Lawrence County Municipal Court. This is your arraignment hearing. We're doing by teleconference. Everything you say today is being recorded. You are appearing in court on a television monitor in the courtroom, and actually the video is being recorded too. You have a right to remain silent. You don't have to say anything. The statements that you do make are on the record. They can be used against you if you admit something about your case. You have a right to remain silent, and you have a right to have an attorney appointed if you can't afford one. You have a right to bail. You have a right to make the state prove the charges against you beyond a reasonable doubt. Do you understand those rights? Do you understand your rights, sir?
Not really.
Okay. Well, let's go over them one at a time and make sure you understand each one. You don't have to say anything. Do you understand that?
Yes.
You have a right to an attorney. You understand that?
Yes.
You have a right to have an attorney appointed to represent you if you can't afford one. In other words, I'll give you a lawyer that you don't have to pay for if you qualify financially. Do you understand that?
Yes.
You have a right to have bail. In other words, you have a right to post, I have to set bail for you, and you have a right to post it to secure your appearance. Do you understand that?
What does that mean?
Well, I determine based on some criteria, your likelihood that you'll appear, whether you're a danger to the community, that sort of thing, what your bail could be. It could be all the way from you signing a promise to come to court and you guarantee your own appearance, or that you have to post cash, or surety means you could use a bail bondsman and they guarantee your appearance. And if you don't show up, then the bail bondsman will come and hunt you down and bring you to the jail for not coming to court. But you have a right to get out of jail, at least to be considered for getting out of jail while your case is pending. That's called bail. Do you understand that?
Yes.
You have a right to make the state prove any charge, and you're going to have two charges. The state has to prove those charges to get a conviction beyond a reasonable doubt. So the burden's on the state to come forward with the evidence and convince the fact finder, which would be either me or a jury in common pleas, that you did what they allege beyond a reasonable doubt. That's the standard for proof in a criminal case. Do you understand that?
Yes.
Do you have the money to hire a lawyer?
I do not.
Do you have a job?
No.
You have no income?
No.
Okay, I'm going to appoint a lawyer for you then. Mr. Thompson. Your lawyer's here, so I'm going to get him in the courtroom. He is in here now. So this is Mr. Thompson. He's going to be your lawyer. Daniel Markins is the defendant's name. He has a misdemeanor domestic violence and a felony for disrupting public services charges. The domestic violence alleges that it happened on December 21st in Perry Township, that he knowingly caused or attempted to cause physical harm to Brittany Markins. Maximum penalty 6 months in jail, $1,000 fine. The disrupting public services alleges that he purposely interfered with communication services, and that usually means interfered with the phone. Yes. The affidavit says it was a phone that he did something to. So that's a 4th degree felony, maximum penalty 18 months in jail, $5,000 fine.
Okay.
All right, so again, I guess we need the prosecutor for a bond recommendation.
We asked for a recognizance bond. Do you have someplace else to go? Daniel?
What was it?
Do you have someplace else to go other than
Yes.
where Brittany is? Where is that?
I can go to my father's house,
Okay.
What's your father's name and where does he live?
Billy Martins in Colorado.
What's the state's position on bond?
We're going to do a protection order, so as long as there's a protection order, we don't oppose no bond.
All right, so Mr. Markins, the standard in this case is that I order that you not go around the complaining party, which is Brittany Markins. And that means that you're not to contact her, go around her, have anyone else do it for you, or post anything about her on social media. Can you agree to do that if I let you out of jail?
Yes, sir.
The main thing is I want this to die down. I don't want there to be a problem because there's probably going to be a week before you come back to court. And I don't want you all getting into it. I don't want you instigating something with her while you're out on bond. You understand that?
Yes.
If she comes around you, you say, stay away, I can't talk to you, I can't go around you. You retreat, go away from her. You understand that?
Okay. Yes.
Can we get a cell phone and maybe his father's number?
Do you have a cell phone, sir?
Yes, sir.
What's your phone number?
740-861-1294.
1294?
Yes.
What, and give me your father's name again?
Billy.
Do you know his number?
Not off the top of my head.
But he lives in Cold Grove?
Yes.
Okay, I'm going to release you on a $2,000 signature bond. What that means is you're going to sign a piece of paper that says two things. One, you promise to come to court when you're ordered to. And two, you promise to stay away from Miss Markins while you're out on bond. You understand that?
Yes.
And then your hearing date's going to be the 30th,
Can we do that Monday?
the next Monday?
Yeah, just.
Well, it'll be Tuesday then, because that's a holiday. That'll be the 3rd.
Okay.
All right, I'm going to set your next hearing date for January 3rd. So that's a Tuesday because New Year's is on Sunday the 1st, Monday the 2nd is a holiday, which we would normally have court, but because it's a holiday, it'll be the 3rd. So you've got to be in court on January the 3rd, Tuesday, at 10 a.m. Court in Chesapeake. You know where the court is in Chesapeake?
I believe so.
Across from the flea market on County Road 1. Okay, you know where that is?
Yes.
Okay, you have to be here, and you don't have any holders from other courts, you're not on probation and common pleas or anything like that.
No.
Okay, so you will get out.
Your Honor, I have a hearing in Cranston, I just remembered on the 3rd.
Do you want to go to Friday, the 6th?
Let's do that.
Okay, so we just changed it because your lawyer has a hearing on the 3rd in another court. So it's going to be 2 weeks from today. So I'm changing it from January 3rd to January 6th. So 2 weeks from today, you're to be in the court in Chesapeake at 10 a.m., January the 6th. So 2 weeks, though, of you staying away from, was there Brittany, is that her first name? Brittany Markins, not going around her, not contacting her, not posting anything about her. Can you do it for 2 weeks?
Yes.
Okay. January the 6th is your next hearing, 10 o'clock at the court in Chesapeake. You'll get out here, you'll have a couple things to sign, then you'll get out in probably before noon today. Any questions, sir?
No, sir.
All right, that's all. Okay, that finishes us up at the jail. We've completed our arraignment section. Okay.
State of Ohio versus Chad Campbell, case numbers CRB 2214 and TRC 222782 A and B.
All right, sir, you're Chad Campbell.
Yes, sir.
Okay, Mr. Campbell, it's alleged that on December the 17th at 1:28 a.m. in Fayette Township, you were operating a vehicle while you were under the influence of alcohol, and that you tested, we'll just round it off and say 11. You tested 11 on a breath test,
Yes, sir.
and it's a first offense.
Yes, sir.
So was that, there's a couple, well, there's one number that's really important about the breath test, that's the per se level. So I'm going to simplify it by dropping the first decimal place. Under Ohio law, if you test 8 or higher on a breath test, there's a presumption, or can be a presumption, that you're impaired by alcohol. In order to get the presumption, the state has to show they comply with the rules for giving the test. There are certain rules and calibrations they have to do to the machine before they give you the test. If they do those things and convince the court that they follow the rules for doing it, if you test higher than 8, it's presumed that you're impaired. The state's alleging you tested 11. 11's higher than 8, so they could get a presumption here that you were impaired. They have to show that evidence that I just told you about before they can get the presumption.
Yes, sir.
If you're found guilty on this offense, there's a maximum and a minimum. Most offenses don't have a minimum. This one has a minimum. I can't go below if you're found guilty. The maximum is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most you can get if you're found guilty. The minimum you can get if you're found guilty is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You understand that charge?
Yes, sir.
Then you've got another traffic charge, failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine.
Yes, sir.
Then you've got a criminal charge, 22-814 is the case number on it. Endangering children. It alleges that on December 17th of this year in Fayette Township, you were operating a motor vehicle while you were under the influence and impaired while you had 1 or more children under age in the vehicle with you. And it's alleged that you also had a combination of alcohol and methamphetamine, I believe, so it says. It just says a metabolite of a controlled substance. So I'm not sure about that. Maybe just the alcohol. The alcohol, if there, in other words, the state's alleging that you had a minor, at least one minor child in the vehicle with you while you were operating under the influence. So that's endangering children. It's a first-degree misdemeanor. Maximum penalty 6 months in jail, $1,000 fine.
Yes,
Do you
sir.
understand the charges?
Yes, sir.
Do you understand the rights you have as a defendant? I explained to one of the previous defendants the rights that you have, and I'm happy to go over it with you if you want a further explanation.
No, I understand.
Any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
No contest.
No contest means you're not fighting the charge. You are agreeing that you can be found guilty without a trial, without having a lawyer. If I believe, I'll hear what the state says it has as evidence against you. If I believe legally that's enough to convict you, then you're agreeing I can find you guilty without a trial and a lawyer. Is that what you want to do?
Yes, sir.
Okay. I'll accept your no contest plea. And I'm going to read the report into the record that the officer submitted to the court. Looks like there was a 1-vehicle crash here.
Yes.
Because I got a traffic crash report from the officer. It says Unit 1 was going south County Road 18 when it drove off the right side of the road into a ditch.
Yes, sir.
And then let's see what, there'll be a further report inside the report. Okay, here's the impaired driver report statement of facts. It says, on December 17, 2022, I was dispatched to a crash on County Road 18. Dispatcher advised that a car had went into a ditch. The occupants had told the caller the police were not needed. When I arrived on the scene, Officer Hawthorne, South Point Police Department, was there. I observed a car stuck in the ditch, multiple occupants standing on the roadside. Car had drifted off the right side of the road and drove with one wheel in the ditch a significant distance. Officer Hawthorne approached me with the driver. He provided me with the driver's information, asked the individual if he was the driver, and he stated that he was. He identified himself as Chad Campbell. He had a strong odor of alcoholic beverage coming from his breath, and his eyes were bloodshot and glassy. Campbell told me that he had 4 twisted T's when I asked. I gave horizontal gaze and nystagmus test and observed 6 of 6 clues on that test. That's the eye test for alcohol. I had to pause and tell the intoxicated passengers to get out of the road on more than one occasion. I moved to the walk and turn test, and then the defendant stopped and stated, I'm not going to be able to pass this. On the one-legged stand test, Campbell performed poorly. He swayed heavily, put his foot down, raised his arms. I offered him a portable breath test that showed a score of 102. There was a total of 5 passengers in the vehicle. 2 passengers were juveniles. One was 14 years of age, and another was 16. Mr. Campbell said he did not know them, and they were friends of other people in the car. 2 passengers were transported from the scene by Lawrence County EMS due to their high level of impairment. They were not believed to be injured from the crash. He was placed under arrest for OVI, transported to the patrol post, and agreed to give a test on the Intoxilizer 8000. It showed a blood alcohol content of 11, basically. Could be rounded off to 12, 119. He was later released to a friend. Okay, any statement or explanation you want to make?
No, sir.
Let's have the prosecutor come in and see if they have any recommendation on that. First offense, it is a first offense. All right, Mr. Heald is prosecuting attorney here. So this is Chad Campbell. He pled no contest to a first offense OVI, failure to control and endangering children. These were not his children. They were friends of a friend, 14 and 16. They were in the vehicle. Any statement or explanation you want to make, Mr. Campbell?
The only thing is, yeah, I did not know those 2 underage people. I just knew there was 2 other people that were 18 and 20, and those are the 2 friends that I knew.
The report, Your Honor, says that there were not believed to be any injuries. This was a crash.
Correct.
Car full of young people. 2 passengers were transported from the scene by Lawrence County EMS due to their high level of impairment. So I don't know what the outcome of that was, or whether those were the minors or not.
I don't know that either.
This is a first offense, and the test score was .119, so it's not outrageously high, but still obviously well over the limit.
Yeah, I don't know if Mr. Campbell had any involvement in their becoming impaired, or if that's something you want to check into, or he wasn't charged with that, which could be an offense if there's some allegation that he was furnishing them with alcohol or some other substance.
Well, I think what we would like to do, if possible, is as far as the OBI is concerned, it is a first offense. If he could be sentenced on that part of it, and then withhold sentencing on the endangering part of it until we can look into the circumstances and make sure there's not something that stands out as particularly egregious.
All right, well, I think what I'll do, I'm just going to delay sentencing on both. I'm going to let the prosecutor investigate this a little further to see if there's anything that would cause there to be an enhancement in the penalty due to these minors being either injured or getting some sort of, if you were involved with them, furnishing them the substances that made them impaired, then that would be aggravating circumstances for the sentencing. So what do you think, couple weeks to get that information together?
Yes, Your Honor.
So I'm going to delay your sentencing. I'm going to make a finding of guilty based on the evidence that I've heard, but I'm going to delay sentencing. I'm going to let you sign a signature bond of $1,000. So you're promising to come back to court in order to.
Yes, sir.
If you don't show up, then you're going to get a warrant and you'll have to pay the $1,000, plus you'll go to jail too for not coming to court. And I'm going to set it for a hearing on January the 6th for sentencing. So you'll get sentenced then. Of course, you're welcome to provide any information you want to at that hearing. I'm going to set it at 10 o'clock on January the 6th. Do you have any questions, Mr. Campbell?
No, sir.
Okay, your order to be back here January the 6th, 10 a.m. for sentencing. Okay, we're going to start the pretrial docket now, so we'll need lawyers and prosecutors to come in the courtroom.
State of Ohio versus Victor Sizemore, case number TRC 222414, A and B.
This is Mr. Vermeen's case, and it's a pretrial.
May I approach your honor?
Yes. This is the court's file, copy to keep.
Yes, Your Honor.
Okay, I have certificate, and I also have a report from the dip school that Mr. Sizemore completed. And this is Victor Sizemore, set for pre-trial, 22-24-14.
Your Honor, I believe the last time we were here, it was discussed, and the court had approved a reduction on the OBI charge to a reckless operation if Mr. Sizemore completed the 3-day DIP school, which he has done. And I think the state's intention would be to make that reduction and $150 fine and court costs. I believe is kind of the standard on that.
Mr. Hill.
Your Honor, previously, Mr. Cremines provided us with a number of medical records that confirmed some infirmities that Mr. Sizemore has medically that would throw into question the field sobriety tests and all the other factors. If you were to discount the field sobriety tests, it would throw into doubt our ability to prove the case beyond a reasonable doubt. So we made that compromise.
All right, so it's going to be amended from an OBI to a reckless operation. You have the statute number.
It's 4511, I believe 201, Your Honor.
201.
191.
4511-201.
I think it's just 451120. That's not coming up to right. Yes, that's it, 451120. All right, I'll impose a $150 fine, court costs. Well, I guess I should ask Mr. Sizemore, you have a right to say something if you want, you don't have to. Do you have any statement you want to make before I send you? $150 fine and court costs. Do you need time to pay that, or can you pay it today?
I'll pay it today, sir.
Okay, so no probation. It's going to be paid today.
Okay.
And then there was a B case. What was the B case?
I believe it might have been Mark Lane's, Your Honor. Case got called before I could grab my
Yeah,
file.
it is. It's a Mark Lane's violation. $10 fine on that. All right, see the clerk, pay your fines and court costs, and your case is complete.
Yes, sir. Thank you, Your Honor.
You're welcome.
State of Ohio versus Janice Seacrest, case number TRC 22-1346. Janice Seacrest.
This is Attorney Roger Smith's case, set for pretrial.
It is, Judge. This is a case we had, because some evidentiary issues, we're going to have reduced the physical control once she goes to school. She used to inform me you're now in the January school, they moved you.
I had the flu, yes, sir.
Okay, when will that be completed?
She's supposed, I'm waiting on her to call me back still. I've talked to
It's
her.
usually the first Thursday of the
That's
month.
what I thought. This last one was, it started in December 15th, so I'm going with the middle of January probably.
All right, and Maddie is appearing by blue.
Is January the 12th to the 15th.
Okay, so we need to come back sometime after January 15th.
Yes.
Do you have, what's good for you, Mr. Smith?
Let's see, Judge. It looks like I'm here Monday, the 23rd. Be the first time I'm available.
Okay, yes, that is a court date. So January 23rd, at defendant's request, is continuance, 23 for pretrial, 10 o'clock.
Thank you.
You're
Thank
welcome.
you, Judge.
State of Ohio versus Jason Lindsay, case number CRA 22522. Jason Lindsay. Did not check in, Your Honor.
That's odd, because I talked to him yesterday. He knew to be here.
You want to try to contact him, or?
Yeah, let's do that. Thank you.
Okay, we'll recall this case later in the docket.
State of Ohio versus Brianna P. Carter, case number CRB 22547, CRB 22682.
And Your Honor, we have a co-defendant, Mr. Watts, Austin Watts.
Okay, we'll call that also. So Brianna Carter is represented by Mr. Stein.
John Eastet. Trina Martin.
When we were here last year, Your Honor, I think we had an agreed disposition, but the issue that remained was one of restitution. It's pretty significant restitution requested in this case, and there's an issue. The alleged victim, I guess, she was on the clock when the alleged injuries took place, but she didn't make an immediate report to workers' compensation, and I guess when she went back, they denied her claim, which last we were here, she said she was appealing that claim, but we don't have any further information on whether the appeal was ever made, or if it was made, if it was upheld, and that's gonna have a pretty significant impact. I mean, we're talking thousands of dollars of restitution, so it's not an insignificant figure.
What I've read in this report that we got from workers' comp, it's a decision by a hearing administrator, or whatever they're called, was that they determined that the injuries were, to Ms. Martin, were caused when she was defending her sister in this fight and not strictly as part of her employment with Speedway. So she wasn't attacked as an employee, she was attacked and injured as a person that was defending her sister. So I think she was going to appeal, but I don't know. You know, nonetheless, there's serious injuries that were caused here. This was a real serious situation. So I don't know whether we just need to have the whole thing set for a trial, or whether they want to plead guilty and we can deal with the sentencing hearing. My feeling is that we're going to have this lady come in and explain herself as far as the restitution, because I don't know what to make of it.
Well, I think, and I didn't make that connection, so the person that was injured is actually a relative of Ms. Watts?
No, Your Honor. The incident involved an employee of Speedway, and I'm not sure and that employee's sister, who I think was just there pumping gas, was what she was doing at the Speedway. An altercation definitely broke out with that. We don't get to the point where we had the police. I'm just, as we look at it, an altercation happened, and the victim he's talking about is an individual who was inside the store and came out and joined the altercation, and in the process allegedly received injuries. She made a claim to workers' compensation. Workers' compensation turned her down, and last we were here, she said she had gotten a lawyer and was appealing. So I think that, like I said, the numbers we're looking at here, I was given the numbers here, but EMS bill alone is in the thousands of dollars, and there's several other multi-$100 bills here. So it's a significant issue if workers' comp were to make a payment on this. So I think that's something we need to.
She's not here today, but we have pretty terrible weather conditions today, so I think could be an excuse for not being here. I would feel more comfortable continuing to another day. And let the state try to get the complaining party here so we can at least hear her explanation.
Right.
And try to sort out this whole restitution issue.
I'll come out and talk to you after the case so I can explain a little bit more to you. Don't leave. Thank you. Oh, we need a new date. I'm sorry.
We need another day.
Yeah, we'll have both of our victims here the next time, or at least we'll try to have that. And by the way, Your Honor, there are two alleged victims, and at least two.
There are three. It's one in one case, two in another.
Yeah, and so.
Do they all have restitution issues? Or
No. The male that's a victim, we at present don't have contact with him. So I don't know where that case is actually going at this point. We're not ready to dismiss the charges, but the other lady who was the one pumping gas, we do have contact with her, and she's the one so far and her name is Tarina Martin. She's the one that's the employee at Speedway. She has given us the records, but I don't know what to make of them as far as whether there's insurance or whether workers' comp is still involved.
She testified she made a workers' comp claim, and she also had health insurance and did not turn any of this into her health insurance as of last time we were here. And I think when we were here last, we also said, go ahead and turn this into your health insurance and see if they'll pay some of it. So we need to have an update on that.
And then the other victim's name's Pamela Hicks. She's the one that was pumping gas, and she became a victim also. And I don't know that she has any restitution to turn in. But we'll have both her and Tarina Martin here the next time if we're able.
Okay, so I'm thinking the 17th or 20th of January.
Let me take a look.
17th is a Tuesday because the 16th is a holiday.
The 17th, I'm in Scioto County. And the 20th, I'm in Wayne County.
Okay, how about, 23rd is already a pretty bad date. How about the 27th of January?
I'm here that day, Your Honor.
And that's agreeable to your folks too.
Can you guys be here that
Yes.
day?
All right, so that gives you plenty of time to get your folks rounded up, Mr. Hill. Hopefully we can get them here.
We'll do the best we can do, Your Honor.
January 27th for our next pretrial. I'm putting down restitution is going to be the major issue. Of course, if it can be resolved, we can always put it on the trial docket. All right.
Thank you, Your Honor.
You're welcome.
Thank you.
January 27th is the next hearing.
Go up to 23.
27.
It's the 27th. Hey, look. Who wants us
State of Ohio versus Amber Rainey. Case number TRC 222571 A and B. Amber Rainey.
This is Mr. Steyer's case at the pretrial, Amber Rainey.
Your Honor, Ms. Ramey contacted me and was unable to get a ride here today. She actually contacted me about a week ago and said that her ride had fallen through, and I told her, well, keep trying and, get right up to the day and let me know. And she called me yesterday and said she couldn't make it, so I'm going to ask for a continuance. I think it is legitimate because, again, she did give me some pretty good notice that it was an issue before it came up.
Mr. Hill?
And we would waive time to
We don't oppose.
accomplish that.
And again, what's your preference for a follow-up date?
We don't need to necessarily go as far, but let's look at the 6th, the 9th, I'm available.
Let's do the 9th. January 9th will be the next hearing for Amber Rainey. It'll be a pretrial at 10 o'clock.
State of Ohio versus Mark J. Seymour. Case number CRV 22484.
And Your Honor, Mr. Seymour is appearing by Blue Jeans today. He had difficulty getting here due to the weather.
I see that he's on the screen now, and this is set for a pretrial. This must be Miss Marietta.
Yes, Your Honor. Absolutely nothing. I have these pretty screenshots on my phone that I can get printed out, and I also got an was not able to get it to Monday, and it was the first. It was not receptive, and counseling and all of it. Like, it was a police organization.
Okay.
But I did update my address and my phone number was there.
Okay.
I just want to be left alone. And I told him that when I didn't have anything. No, I'm going to say.
Let's do that. Morning, he needs to have been done back with you, and he needs to do his counseling, and then schedule dismiss the charges later on. Or we can just say we want to have trial. Your Honor, if it please the court, way back on August the 19th, we were in court. Ms. Marietta was here, I believe, at the time, and it was agreed that if Mr. Seymour attended to some counseling with Chesapeake Family Medical Center, that at a later date, we would agree to a dismissal of the charges with payment of court costs if he completed the counseling and left Ms. Marietta alone. So neither of those things has happened. In fact, he's continuing to harass her. She's expecting, and it's causing her immense amount of stress. we don't believe he's finished his counseling. And so we believe that we're not able to stick to that original agreement. We are going to seek a conviction in this matter. And
set for trial then?
unless he's willing to plead guilty.
Well, I'm certainly not gonna ask him to plead guilty at this point. I didn't become aware of this until now, so at least we would need another pretrial. Either one more pretrial and then a trial date or a trial date.
I'll set a pretrial, but Miss Marietta does not need to be present for that. You're welcome to be present for it if you want, but you've already, is there anything else you want his lawyer to know that hasn't been stated today?
I just want left alone and I don't even really want to deliver. Like I just want.
Well, I'm gonna let you know, sir, that we need to ask you to don't have any contact of any kind, including text messages, Facebook messages, instant messages, posts, nothing. Just please have no further contact. We'll come back in here, we'll regroup, see where things are, and maybe set a trial date.
And Your Honor, I've also advised Ms. Marietta that she should get a civil protection order as well.
Okay, when do you want to come back for the pretrial?
Your Honor, 6th of January?
Yes. January the 6th, pretrial at 10 o'clock. And ma'am, you're welcome to be here in person, or you can appear by teleconference. He's raising his hand. I don't know if that's...
Were you wanting to say something, sir? I'll give you a call after I step out of the courtroom.
Yes.
I don't think his sound's on. Your sound doesn't appear to be on, sir, but it's probably better that you say what you need to say to me, and I'll deal with it if need be, okay?
All right, so January 6th will be a pretrial. You're welcome to be here in person. You can, we've got several options now. You can, if you want to say something and be a part of it, you can appear by blue jeans. If you just want to watch, all of our court sessions now are on YouTube. So you can watch the proceedings and see what happens and hear everything that's even whispered in the courtroom. Okay, January the 6th is the next hearing at 10 o'clock.
Thank you.
You're welcome. Thank you.
State of Ohio versus Hobart Gearhart. Hobart Gearhart. Case number CRB 22804. And several minutes.
Mr. Gearhart's here, as is his counsel, Mr. Morford.
Good morning, Judge.
How are the cows?
They're hanging in there. I got a few left.
This is probably pretty rough, going to be a rough weekend on it.
It's a rough night, I know that. And I'd like to say congratulations. I heard you got married.
Yes, sir, I did. Thank you.
Judge, to bring you up to speed, he has retained Brian Cremines for his probation violation in Ironton. Brian was able to obtain his release upon a bond. He has to have a new AOD assessment and follow up with whatever treatment is recommended. I don't know if Mr. Hill wants to leave this pending here and see how it does then. I think early on we were discussing maybe a global resolution of a number of cases.
Your Honor, our primary concern, besides Mr. Gearhart's well-being, personal well-being, which I guess he offended him the last time we were in court, I think it to be a bad thing, is the fact that the neighbors, of course, have suffered a long time with these cows trampling on their property, and that's got to end. And now I believe that there is a good reason for there to be some order from the court saying it has to end. There have to be no more cows. That's not to say that we would oppose him having cows forever in the future, but this needs to get resolved immediately. As far as the amount of jail time that could be ordered, I mean, he was found guilty on several of these charges. That's not our goal. Our goal is to fix the problem that's led to all this. And then he's got a separate issue in common police court that the new AOD assessment sounds like a good start there. And he was ordered, I believe, on the OVI charge that we had him, we agreed to amend it to a physical control, but I think treatment was part of the orders on that. So we wanted to continue.
Yeah, I don't have a problem with that, Your Honor. I'm doing what I've been doing.
Where are you at?
As far as the new charges go, we would agree just to hold on to those and maybe dismiss them at a later date. We felt like we needed to go ahead and file them just because it's just, continued to be an issue. But it's the same issue over and over again.
How many cows do you have now, Mr. Gerhart?
10, I believe, 10 or 11.
Okay. Do you have any plans on getting any more?
Everything I got young now, she got rid of all that, all my cold cows and everything I got young now.
So they will be there. You anticipate keeping them
Well, I
there
got
for a while?
4 bulls I'm gonna be getting rid of. I'll be killing them, so, I'll have a few calves coming, but everything, as far as, I got a few heifers, and then I'll be killing them bulls, so.
And you're willing to maintain the fence that surrounds the property?
Yeah, my fence is new, brand new, 5-strand barbed wire, it's brand new, all new materials, nothing on sheath, all brand new materials.
Well, what I'd like to do is continue this. I want, there has to be an end to this problem with the cattle getting out. And I will order them sold if I have to. I don't know how that would, actually, the mechanics of that work if I ordered it, because the sheriff would have to do it, and I don't know that that's ever happened before, so I don't know how we could make that happen. I prefer, it'd be a lot better, Mr. Gerhart, if you would take care of the problem on your own. It's going to be much better for you, the sheriff, the court, everyone, if you get this under control. Get rid of the animals or whatever it is you have to do to make sure this doesn't happen anymore, because it keeps happening repeatedly.
I agree, Your Honor, but I was in jail for a
I
month.
understand that, so I'm going to give you a little more time to deal with it and get it under control, rather than me sending an order down to the sheriff saying you gotta sell these animals, because I think he would probably start scratching his head about how he's gonna do that. So I want to put him in that position, or you in that position, because you're gonna be a lot happier if you take care of it.
I will, sir, thank you.
So let's come back in a couple weeks, and I want some solution to this. Either you put them on somebody else's property, I would accept that. If you got a friend that will take them for a while, or you've sold them, or I just want to be assured that this isn't going to happen anymore.
Okay, I'll try to figure something out.
So let's, I'm looking at, that would be the 6th of January. Are you available then?
Yes, sir.
Okay, January the 6th, and it's going to be pre-trials in there. I think there's sentencing on the one case that's already been found guilty on, if not more than one.
Several, 4, I think.
All right, January the 6th will be the next hearings. Let's get a solution to the cows before then.
Judge?
Yes.
We've got several case numbers, and I'm going to put a time waiver on the ones that are still pending that aren't on for sentencing, and I don't know what the newest case numbers are.
Okay, I've got 22-804. That's a fairly new case. The D or OVI was 22-2479, but he's already pled guilty to that, so I don't think we have to worry about that. The newest case looks like it's just that 22-804. There was a 22-477. There's already been a plea on it. It's been set for sentencing. 22-477. Same thing on 22-383. Okay, now 22-764, I don't think has ever been resolved. So that one probably, that's another animals running at large from December 2nd. We got one December 2nd, one December 16th. So 22-764 needs to go on there.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Matthew D. Turner, case number CRB 22-805, CRB 22-474 A and B, CRD 18-3631, CRD 18-2463 A and B. Matthew Turner.
And this is Mr. Morford's cases.
He did not check in.
At one time, he was at ODP.
Judge, my last note, I've got 5,000 OR bond released to hometown.
Okay, that may have been the last case, 2285, police hometown for treatment. Anyone? I wonder if he's still there. Can we check, you have contact with hometown?
Yes, Your Honor.
Can you check to see if a Matthew Turner is there, inpatient, Matthew Turner?
Yes, sir.
And my notes said it was going to be hometown in Gallup Place, so.
Okay.
Yeah, that's true.
We'll recall this.
Thank you.
State of Ohio versus Aaron Wells, case number CRB 22756.
All right, and you're Aaron Wells.
Yes.
Do you have an attorney, sir?
No.
This is on a failure to confine a dog, looks like.
Yes.
What's the state's position on this? It's filed as a minor misdemeanor.
Yes, Your Honor. We did some checking to see what we could find out in addition to what we knew already. And the neighbor believes that these dogs that are the subject of the complaint actually, if Mr. Wells doesn't claim them as owning them, he still either feeds them or takes them in or something. If it's not the case, then I guess our position would be that they should be turned over to the dog warden. So if he's willing to do that, we can come back again. I don't know, I mean, it was a sheriff's deputy who made the report. It was not the dog warden. So when we talked to the dog warden, he said, well, I don't know anything about it. And that's really kind of, do we know any more than that? Okay. Yeah, we also were going to try to confirm, although I think we've confirmed through one of our witnesses that Mr. Wells does have the one dog that is the one that he, I don't know, lives in the house or whatever. And, and that, but we don't have that from our enforcement officer yet at this time. So I guess, you know, one of the things is we got, I guess apparently a bunch of dogs running around out there that either nobody claims or whatever that need to be picked up. And if Mr. Wells agrees with that, maybe he would even cooperate in helping getting them rounded up.
Yes, they live 2 doors, well, 1 door down. It's about 100 yards from me is where all the dogs are. If you drive out through there, they'll chase you and everything else. But I only have 1 dog and he stays in the house unless he outside with me or uses the bathroom.
So how do you want to proceed, Mr. Field?
Well, what I would like to do is have, our alternatives are just to ask for a trial in the very near future, or if Mr. Wells would give us some time by waiving time, I would ask the enforcement officer to go meet with Mr. Wells and whoever else we have as witnesses, determine where the dogs belong or don't belong, and have him round up the dogs. If they don't belong to Mr. Wells, then he's not going to object to them being rounded up. And if we find out that they belong to somebody else, then we'll charge them. But, the primary thing, I don't know how many dogs it is. Do you know how many dogs it is?
There's at least 3 of them that just run free.
So it's a problem that needs to be figured out. And so that's what we would like to do, if Mr. Wells would agree to give us some time to do that.
Mr. Wells, how do you feel about this?
Yes, that's true.
You're agreeable with that?
Yes.
So a month, long enough time to get this done, Mr. Hill?
Yes, Your Honor.
All right. Mr. Mr. Wells, what's your, are you employed, sir? or-
Yes, employed.
Do you have a preference as to a date? And I actually would let you, if you want to appear by teleconference, you can do that, it might be more convenient for you.
I can appear at any time. I work local, so.
Monday or Friday, one
Yes.
works for you?
Yes.
Well, let's do January 30th, that's a Monday, January 30th.
Okay.
All right, next hearing is January 30th for a pretrial, 10 a.m. And expect a contact from the animal control officer, or otherwise known as the dog warden. And do you have his contact information, do you have a cell phone where the dog warden could call you?
Yeah.
I'll give you that.
740-861-6003.
All right. His name's Ronnie. I'll get a hold of you.
All right,
Thank you.
Okay. All right, is Mr. Stratton available now? I see you on the blue jeans. Mr. Stratton? Yeah, there he is.
Yes, sir. State of Ohio versus Justin Casey, case number TRC 222460, A and B.
Okay, Justin Casey. Okay, he's supposed to be a Spectrum inpatient. Is he at Spectrum?
Your Honor, I apologize, I did not have him on my calendar today.
Or driving.
Mandy, do you have a record of a Justin Casey?
Yes, he's at our male residence house.
So he is inpatient then?
Yes.
How's he doing?
He's doing good. He's been here for maybe about a couple of weeks.
Okay, great. So I assume what we'll do, since he's inpatient at Spectrum, just continue this for a while and monitor his progress. Is that agreeable, Mr. Stratton?
It is, Your Honor.
Mr. Hill?
We're not opposed to it, Your Honor. I would like to state something in addition, if I may.
Go ahead.
This case was brought over from Mayor's Court, and on the ticket, it's alleged that it's a third offense and a high score. But with respect to the third offense, we didn't get a driving record for me to confirm that. So we're going to ask for that to figure out whether it is, if the ticket doesn't say the years or anything on it. So
Okay.
we're going to be checking into that. And we would also ask for a time waiver.
Mr. Stratton?
We have no problem at the time, Your Honor. I should have filed something that said time waiver on it.
Okay, so what I take it, the state's investigating what level of offense this is. There's some indication it may be a third offense, but they don't have the exact conviction dates or information at this point, so they're going to investigate that. But at this point, Mr. Casey is inpatient. I encourage that. And it's my understanding he's going to agree to waive time while he completes it. And
Yes. Yes.
come back in about a month. I'm looking at perhaps January 30th as the next hearing date. Is that agreeable, Mr. Stratton?
Your Honor, can we do that Friday, maybe the 3rd?
Yes.
Okay.
February 3rd will be the next hearing date
Thank you, Your Honor.
for a pretrial. And the only thing at Spectrum, if something changes with regard to Mr. Casey's status, if he leaves or is not doing well, I'd like to be notified of that before February 3rd.
I sure will.
All right, thank you. February 3rd will be the next hearing.
Thank you.
State of Ohio versus Robert Parker, case number CRB 22554, and a new charge, case number CRB 22798. Robert Parker. Did not check in, Your Honor.
Robert Parker, and I think, Mr. Stratton, you're representing him on the, well, this is the case that's set for, is this the case that's set for the jury trial on January 3rd?
It is, Your Honor.
It is, Your Honor. I spoke to the court yesterday about a parent by the blue jeans, and I was told that Mr. Parker did not have to be here today, so I told him not to be here. I understand that there might be some scheduling conflict for the January 3rd trial.
Well, I possibly could do it. Let me check my schedule. I didn't know if you would want to continue since there's a new charge, but it's related to the old charge, I believe.
Well, it is, Your Honor. As a matter of fact, it's the same identical facts. And so there are two individuals that are subject to the same order, and that order was violated at the same time by the same acts of the defendant. But since we were going to have a trial, we figured instead of just not addressing the fact that he violated the protection order twice, if he was going to agree to something, we wouldn't worry about it. But since we're having a trial, we decided we needed to have everything before the court.
Well, I do have something scheduled on the 4th, but that's something that, I thought it was something that couldn't be changed. It is something that I could change. I am tied up to the 5th with hearings in the common police court, but I think we should be finished. And that would give us a day and a half. I would think that would be more than enough to do this jury trial.
Your Honor, me and the prosecutor spoke earlier this morning about a possible resolution. If the prosecutor is okay with it, and for convenience of the court, I have no problem continuing it to a later date. Maybe set it for another in-person pre-trial and have Mr. Parker present.
Well, what I'd like to do, because we've already notified the jury, why don't we just set another pre-trial, and then if it's resolved, we can call the jury off. If it's not resolved, we'll just let them keep coming in, because we're already getting calls. So we could set it for, probably it'd be best Tuesday of next week, or probably best, or we could even do the 30th. I'd prefer to do the 27th. You think you can talk with your client before then and be ready to discuss this on the 27th?
Yes, I'm actually out of town on the 30th, the 27th would be best for me too, so, and I'm supposed to be there at 4 on the 27th, so we could be there, that'd be fine.
Okay, let's just set everything in this case again for the 27th, and then we'll need your client to be here. Do we need input then from the complaining parties on the 27th?
Well, I'm in contact with her even this morning.
Okay.
And I've been considering different ways to resolve this, and I think maybe I've come up with something that would be satisfactory.
But she'll be reachable on the 27th?
She will be reachable, yes.
Okay.
And also, Your Honor, I don't know that it's been filed, but I've prepared a motion to consolidate both of these charges for trial, which I would assume.
I do have that before me. Mr. Stratton, have you seen the motion?
Yes, I've received it, yes.
Do you have any objection to consolidating these?
I don't, it's out of the same incident, same situation, so there's no objection to consolidation.
There's no surprise in facts, in other words. It's the same facts that would be presented in both cases, it sounds like.
Yes.
Yes, correct.
Okay, so I'm going to approve, I'm going to say verbal approval of the entry, today's date, and I'll sign the entry consolidating these for trial. But hopefully we can still reach a resolution. We'll consider doing that on the 27th. So I'm going to put both of these matters on the court's docket for a pre-trial this coming Tuesday, which is December 27th.
Okay, thank you, Your Honor.
10 o'clock. Anything else we need to consider on these cases, Mr. Stratton?
We'll just pre-trial on 27. Thanks.
All right, thank you.
State of Ohio versus James McClaskey, case numbers PRC 19975 A, B, and C, CRV 19274.
All right, and this is also Mr. Stratton's case, and Mr. McClaskey is here in person today. This is, I believe, on the docket is a sentencing.
Yes.
We've just been continuing this to allow him to get the things that he has been ordered to do completed. And it looks like there's still community service and fines and costs owed.
Yes, sir. I'm working on it, but we had to get a car, and that threw me behind. But my check loads, I think, when?
Do you have any payment on your fines today?
I've got like $20-some on me.
We'll take that. Put you down for 20. And let's set this, I'll set it a month out, so that's January 23rd. Will be your next hearing. Get your community service done also. And there'll be a sentencing hearing, because he has a bond up now. So I don't know if you were actually involved in this anymore. I think you were the attorney. Initially, Mr. McClaskey had to post a bond for missing a review hearing previously.
Your Honor, I was just on the original case.
All right.
What time?
10 o'clock, January 23rd.
Yeah, but now that I got a ride, I'll get that community service taken care of.
Okay, thank you, sir.
Thank you.
State of Ohio versus Kara Walesick, case number 22, TRC 2589 A and B.
This is Mr. Stratton's case, set as a pretrial. This is going to continue from December the 2nd to today's case, and it is, looks like a second offense OVI with a refusal. You had any contact with Ms. Walesick? All right, because of the weather conditions, Mr. Stratton, today I'm giving people 14 days before a warrant will issue rather than 7, so I'll give her 2 weeks to, if you can let her know she needs to come in the next 2 weeks or she'll have a warrant issued, so bench warrant.
State of Ohio versus Cody Smith, case number TRC 22-2099 A and B.
This is Mr. Kameen's case set for pretrial.
Your Honor, this is a first offense OVI and an assured clear distance case. After speaking with Mr. Field on this matter, I believe we have a proposed resolution of the court. My client will enter a no contest plea but stipulate the facts sufficient for a finding of guilt and in exchange for standard first offense treatment as recommended by the state.
And there was insurance here.
Correct.
And was this incident turned over to the insurance company?
It was, Your Honor.
He was going to do his treatment as part of the There was a collision and there was insurance, and so I believe that part is taken care of. It's my understanding that Mr. Smith was taking part in some alcohol counseling, and we want that to be part of the orders in addition to the standard first offense treatment.
Your Honor, he's been attending AA meetings. If the court feels that there should be further assessment and follow-up treatment, we would have no objection to that.
Okay, well, what I'll do, I think, is, which is typical, I'll order that he do, because he has to do the driver intervention program, and they'll do an assessment. If they recommend additional treatment, then that'll be a part of your probation, that you do the additional treatment. If they think that what you've done with them is sufficient, make that recommendation, then I won't require it. Of course, if you feel like it's helpful to you, you can do it on your own, but it just won't be court order. So, Mr. Smith, do you agree with what Mr. Cremeen says, represented to the court?
Yes, sir.
You have a right to make a statement if you want to before sentencing. You don't have to make any statement. Do you want to say anything?
No, sir.
Okay. I'll accept the, was it a no contest or a guilty plea?
No contest, Your Honor, but we're stipulating to a guilty finding.
Okay. Accept the no contest plea, make a finding of guilty.
First offense.
It's a first offense. Is there any explanation for the refusal? Because usually I give a higher fine if there's a refusal.
Your Honor, I don't believe there's any explanation on that other than at the time frame. I'm not sure, but it didn't seem like the troopers wanted to go down and do it. No objection to that, Your Honor.
All right, I'll impose a $1,000 fine. Order the cost be paid. 6-month license suspension, and that starts the day of the offense, so you don't have too much longer on your suspension to do. Did have insurance, 20 days in jail, all suspended on the condition that you do 5 days of community service, serve 2 years of level 4 probation. Does he have driving permit now, or?
Do you have a driving privilege currently from the court?
Oh, I believe so, yes.
I believe so, Your Honor.
Okay, I'll give him a driving permit until his suspension's up, which is January 13th, so he doesn't have to much further, and that can be for work, community service, and treatment. Is there anything else you need driving privilege for?
School, I believe, Your Honor.
School's online, but I have visitations with my son 2 hours a week.
I'll do it for childcare then also.
Okay.
Thank you, Your Honor.
Thank you.
And then when this is up, you'll have to contact, your license just doesn't automatically go back to being reinstated. You have to contact the BMV. They'll make you pay a reinstatement fee, maybe show proof of insurance. It'll be up to them what they require you to do to get your license back. But you need to do that once the suspension up, which is January 13th. I would actually contact them before the 13th to make sure you got things lined up to get your license reinstated. There was a sure clear distance ahead charge. I'll impose a $20 fine on that. And set review hearings for July 24th. You'll need to get in touch with Spectrum about getting your 3-day school done. Usually there's somebody here, but because of the weather, Maddie is online. But you can get their phone number from the probation officer. You're going to have to meet with Mr. Major in the probation office, and he can give you the contact information for Spectrum about the 3-day school.
Thank you, Your Honor.
Any questions, Mr. Smith?
No, sir.
Okay. See Mr. Major, probation, then you're free to go after that.
All right, thank you.
Thank you, Your Honor.
State of Ohio recalls Jason Lindsay, case number CRB 22522.
I wasn't able to get a hold of him, Your Honor, but I did talk to him yesterday. And he told me that he had been in residential, I guess completed that, and was doing AA now. So the only thing I can think is the weather.
Do you want to ask for continuance?
I would like that, and I would ask that we continue to the 9th, which is a Monday. And that one I do have a conflict on, so if we can move that to the 9th.
Is there any objection to continuance to the 9th?
On who?
This Jason Lindsay.
Oh, no.
All right, finished request. This case is continued to January the 9th for pretrial, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Marisha Short, case number CRA 22-623, CRB 22-624, PRC 22-2494, A and B.
Your Honor, she's at Bethesda, and she's compliant with all treatment recommendations.
All right, thank you. That was Taylor Jones Durham speaking from Bethesda. Mr. Morford is here as counsel for Ms. Short. Counsel agreeable to continue to let her continue in her treatment?
Absolutely, that's exactly where she needs to be, in my humble opinion.
Mr. Hill?
We don't oppose it, Your Honor.
January 30th?
Thank you, Your Honor.
Let me check that date, would you? Okay, I'm good then, January 30th.
It's continued to January 30th. Of course, Bethesda will notify the court if something happens before then, please.
Absolutely.
Okay, preliminary hearing, 10 a.m., January 30th.
Thank you, Your Honor.
You're welcome.
Very much.
State of Ohio versus Jacob A. Williams, case number CRA 22-806, CRB 22-807.
Jacob Williams is here today. Do you have an attorney, Mr. Williams?
No, Your Honor. I called Trulio, and he couldn't take my case, so I called Richard Nash, and later today I'll be finding out if he can. If not, I got his number.
He asked for a card from me earlier this morning,
Yeah.
passed it along, but I haven't familiarized myself with the case in any way yet.
All right, this is set for what's called a preliminary hearing and pretrial today, so I'm assuming since you don't have counsel, you want to ask for a continuance of that
Yes.
to another day?
Yes, Your Honor.
Do you have a preference as to when to come back for that hearing?
The 16th, if that'd be all right.
16th of January?
Yes, Your Honor.
Yeah, there'll be it would actually have to be the 17th, because 16th is a holiday. Is the state agreeable with going out that far? How do you want to proceed, Mr. Hughes?
We are agreeable, Your Honor, as long as there's a time waiver. And I would also add that I'm going to attempt to have our arresting officer here, because I want a more, not that this wasn't a lengthy explanation, but I want to find out exactly, this is if the court's read the charging document, it's not one that we have seen a lot of. And I want to know from the officer's perspective how seriously he believes that this threat to him was. Basically, it was a gun that it's alleged Mr. Williams reached for and put his hands on while the officer was dealing with him. So it could be something that he takes very seriously, or it might be something that we could work out here, and I just don't know yet.
All right, so we'll come back on the 17th. Are you available then, Mr. Williams?
Yes, Your Honor.
All right, January 17th, at your request, you'll need to sign a time waiver that Mr. Hill's going to prepare. You have a right to have a hearing earlier than that. So it'll be set January 17th of 23 for preliminary hearing and pre-trials at 10 o'clock.
Yes, Your Honor. Thank you.
You're welcome.
State of Ohio versus Benita Lynn Hodge, case number CRB 15986, KRD 182433, CRD 151124, CRD 131814.
Angeline Hodge.
Is this her?
It doesn't look like Cecily Weaver on the.
It doesn't appear to be her.
Okay. Well, I'm shocked. Ms. Hodge is not here. But she always is.
Yeah. I don't have any information on Ms. Hodge's whereabouts, Your Honor.
And she always appears by teleconference, so. Can't be the weather.
Could be, the lights could be down.
Well, that's true. I'll give her 14 days before a warrant issues.
Thank you.
I saw the AED drugs and the aspirin drugs out this morning because it must be increased. You know, you get nice bonus. Yeah, so that, to me, may not have a number. It's true, she got it. That could be it. That's probably the only likely explanation. That seems the most likely.
May need some new covers. Run out of space.
Need a new file. I need to bring some out here, I guess.
State of Ohio versus Robert Heft, case number TRC 222226, A and B.
Your Honor, Mr. Heft contacted me this morning. He is, he said he had tried to contact Riverside, who he's in treatment with, to get a ride down here today, and nobody answered. I would assume that due to the weather, they just didn't open at all, although I don't know if anyone's here from there. So that's probably why he's not here, but it seems like a legitimate reason not to be here under the circumstances, so I'm going to seek a continuance.
Okay, and I do have a report on him from December the 8th, although we did set it rather quickly.
Yeah, we needed to have him in here, Your Honor, but I think the circumstances really are legitimately beyond his control.
He had the flu on the 9th.
Okay. So, what is your request?
I just, a continuance to a date that the court deems appropriate.
Mr. Hill?
We don't oppose it, Your Honor.
So upcoming, I'm here the 27th and the 30th. I'm here.
Let's go into January.
3rd or the 6th.
Let's try to keep the 3rd light. Let's do the 6th, January 6th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Stephanie Plumley, case number CRB 22584.
All right, Ms. Plumley called the court, said she couldn't make it here today. She's promised to be here Tuesday, so if there's no objection, I'll just put it on the docket for Tuesday.
We don't oppose it, Your Honor.
Which is the 27th, so due to weather, it's continued to the 27th.
State of Ohio versus Heather Rieger, case number CRB 2214. Heather Rieger.
Set for sentencing, still have community service left to do.
Yeah.
When you gonna get it done?
Hopefully very soon. I go back to the doctor from where I broke my knee on the 27th, so I'm hoping everything's taken care of there.
Okay, I'll set your next hearing for February the 10th. If you get it finished, you don't have to come back.
All right, thank you.
February the 10th, sentencing, 10 a.m.
Have a Merry Christmas.
Merry Christmas. No, it's Weaver, Melissa Weaver.
Okay.
All right, Ms. Weaver, I see you're here at the teleconference. All right, let's.
She was on for a review.
Okay, let's pull your, we already went past you, but we'll go back and pull your file. Melissa Weaver. She's been on there all morning. I don't know if we missed her at the review. All right, I have your files now, Ms. Weaver. It's case number 16490. That was a disorderly conduct that just had a fine. 10251 was a driving under suspension, had fine and community service, which you did the community service. 09120, endangering children, which just had a fine, and that's it. And let's see, you made a payment recently, so, okay. Okay, we'll keep working with you. Okay, your next hearing is going to be, does it matter to you if it's Mondays or Fridays? I'll make it for January the 23rd, exactly 1 month. 1/23/23, 9 a.m. Any questions, ma'am? Do you have any questions, ma'am? No? I can see your lips moving, but nothing came through. Did you say, no, you don't have questions? Okay. 1/23/23, 9 a.m. is your next hearing. Okay. Again, your audio is not, I don't think I've got you off. Let me see if I do. Your audio is not coming through. And it's not on my end, so maybe have you got it blocked there? Try again. Yeah, it's not coming through. I can see you're trying to talk. Can you hear me okay? Okay. It barely came through that time. Yeah, it's turned way up. You got the date, right? Your next hearing date? You got that? All right. That's all. Thank you.
State of Ohio recalls Matthew Turner, case number CRB 22805, CRB 22474A and B.
Your Honor, let me check and see if Mr. Major got a phone call back.
Okay.
From home.
Mr. Turner's supposed to be inpatient at Hometown Recovery in Gallagher County.
He did not get a return phone call yet, Your Honor.
Okay. Well, that's disappointing. They have not. All right, what I'm going to do, since he didn't appear, at this point, I'm just going to put it on the failure to appear with a 14-day. If we get a call back from them and he is there, then I'll remove it from the warrant file. I think that's it. Okay, court's adjourned.
Happy New Year.
Happy New Year.
That's spares. Spares.